When you purchase a property, there are many ways you can hold title to it. Do you know the different ways and what they mean? Hi, I'm Gabby Laterno with loansbygabby.com and Ameris Bank Mortgage Services. Let's talk about the different ways you can hold title to a property and what it means for you as the owner. All right, first up is sole ownership. This is when a sole individual or entity that's legally capable holds title to the property. So if you purchase a property by yourself, you would hold sole ownership since you don't share ownership of the property with anybody else. Tenancy by the entirety. That's ownership between married people, which each owns the entire estate, with the survivor taking the whole estate upon the owner's death. So if you and your married spouse purchase a property, you are both owners, but if you or your spouse pass away, then the surviving spouse has full ownership. All right, now with the trust, the legal title to the property is transferred by a grantor to a person called a trustee, to be held and managed by that person for the benefit of the people specified in the trust agreement called the beneficiaries. Okay, so next is a community property. That's a form of ownership where spouses or domestic partners own equal interest in the property. Okay, next is tenancy in common. An estate or interest in land held by two or more people, each having equal rights of possession and enjoyment, but without any right of succession by survivorship between the owners. So you and let's say your sibling own a property, you would own it 50-50. If you or your sibling passes away, you still own your 50% and their 50% may be passed down to their heirs. Okay? Joint tenancy with right of survivorship. This is an undivided interest in property taken by two or more joint tenants. The interest must be equal, accruing under the conveyances and beginning at the same time. Now, upon the death of a joint tenant, the interest passes to the surviving joint tenants rather than to their heirs of the deceased. So if you and your sibling own a property, you would own it 50-50 unless one of you passes away. If one of you passes away, then the portion that you owned in the property would be given to the other owner. Okay, so the person that passed away, their ownership is given to the other owner. So now that you know the different ways to hold title to a property, you can ask your lender how they have it set up for you to hold title when you get under contract. Don't be shy to ask this question. Most lenders just choose an option they think is best and move on. Make sure if you're not using me as your lender, that the lender is actually knowledgeable and they're looking out for your best interest. Contact me if you want to make sure you are top of mind, not just a commission check. I'm Gabby Laterno with loansbygabby.com and Ameris Bank Mortgage Services.